In North Carolina, a person charged with driving while impaired could be asked to submit to a chemical search of their blood. Normally, the state is wanting to look at the blood to see if there is any alcohol in the blood and a specific amount, looking for illegal controlled substances, and also looking for prescription medications. In order to get a person's blood, normally the state is required to obtain a search warrant. A blood search is a very invasive and intrusive search by the state, and typically a blood search warrant would be required in order to effectuate such a search. There are exceptions to the search requirement, including a person that gives consent to have their blood drawn. The state could also argue that there is an exception due to what are called exigent circumstances, that the situation itself creates an exigency so that a search warrant would not be required. Typically, in order to show exigent circumstances, the state must show above and beyond that alcohol is merely dissipating from a person's blood. So it's not enough to show that alcohol is leaving the person's bloodstream, that the person is eliminating alcohol, and therefore there are exigent circumstances based on the fact that if we take a couple of hours to get a search warrant, then there won't be any alcohol left in the person's bloodstream. That is not enough in itself to create exigent circumstances. Normally, the state can also draw blood in North Carolina of an unconscious person. Under North Carolina General Statute 20-16.2b, a person that is unconscious and has been charged with impaired driving can have their blood drawn. I have recently seen a judge strike down a search that was effectuated under 20-16.2b, finding that that was not it was a per se exception to the warrant requirement that was disallowed by the U.S. Supreme Court's ruling in Missouri versus McNeely, due to the fact that 20-16.2 creates a warrantless exception to the search requirement, and it does so in a per se or entire fashion, that it's not determined on a case-by-case basis. It is always wise to look at challenging any blood draw that has occurred if there are constitutional or statutory challenges that can be made to a blood draw that was taken related to a driving while impaired charge.